Hello, I'm Qudus Adeoye, member of the dispute resolution team at KENNA. Today on KENNA Law Café, I'm joined by my colleague Adeyinka Adegbite. Welcome, Adeyinka.
Thank you, Qudus. It's a pleasure.
We're looking at a very important issue in the Nigerian criminal justice system. It's the issue of prior detention and sentencing. In our experience, we realize that most courts, or some courts, make mistake in the calculation or factoring in of prior detention in sentencing. Adeyinka, I want to ask, what's your idea of prior detention and sentencing?
Simply, prior detention is any detention that occurs before conviction, from the point of arrest of a convict and conviction. Sentencing, on the other hand, is a stage in the criminal administration process, and it comes after conviction.
Well, that's very interesting. But I would like to confirm exactly, how do you think prior detention fits into the bill of sentencing?
So this section 315 of the Administration of Criminal Justice Law of Lagos State, which is in focus, directs a court to consider prior detention of an accused person in reckoning the length of imprisonment that an accused person will undergo. So what it means is that while the court is imposing a sentence upon convicting an accused person, the court must consider if there has been any prior detention that this accused person has been subjected to before conviction.
Well, thank you so much for that. Then I would want to ask, does extrajudicial detention count? By extrajudicial, I mean detention as we usually see it in practice, where maybe the remand order has been made for a very long time, or a person is at the police station or at the EFCC or ICPC. Do those kind of detentions, do they count into this timeline?
Essentially, the point of detention must be, or the detention must be on account of the crime that an accused person is convicted, on. So what it means is the detention, the arrest, like you said, by either the police, the ICPC, or other law enforcement agency must have been done on the basis of a crime that the accused person is convicted, of. So if a person is arrested and detained on the basis of an allegation, or the basis of an allegation of, say, stealing, whatever the detention period will then start to count up to his conviction on that allegation of stealing for it to be taken into consideration. So what it means is it must be on account of that crime that is being alleged.
Well, Inka, I mean, I get your point absolutely, but I think from what you said, I can just distill it that you mean it would count. I mean, all manner of detention would count, except that perhaps there's importance of what those detention are about. I mean, the nature of the offense and all of that.
That's correct.
But I would think generally they would count.
They would count.
But I dare say that what we've seen in practice is a stark contrast to what you're saying. I mean, I know of a light case where even after conviction, the remand, the conviction was supposed to start from when a formal remand order was made. But the accused person in this case had been at the police as well as even at the correctional service for at least 3 years. And this was not factored in. So the question I want to ask is this kind of development, is it, or are they ideal?
It is not ideal, especially in Lagos State, because all our references must be to the Administration of Criminal Justice Law of Lagos State. And why I said this is because the ACJA, that's the Administration of Criminal Justice Act 2015 that operates in Abuja and some of the states, the Federal High Court, and some other states, does not make provision for prior detention. So what it means is that it is particular to states that have that provision in their law. So bringing that home for states that have that provision of prior detention, it is not ideal
Yeah.
because the law mandates that prior detention must be taken into consideration. So it is not an ideal situation.
Thank you. And if I may also add to that, I would say that even outside Lagos, I mean, I can recall of this authority, Bayo Akande and the states, 2013. It's a Supreme Court decision. Even when, you know, that provision is not expressed in any of the procedural law being relied on by the Supreme Court faulted an imprisonment of 21 years that was handed out that did not factor in the day or the prior incarceration of the accused. The court felt that it wasn't in line with good justice, basically. So I would even say that outside Lagos, this kind of authority is an example of when the court would be required to do substantive justice and, you know, not just be so strict with the letters of the law. I'm just saying this, but I get your point absolutely. Thank you so much for that. So outside the ideal, I was going to ask you, what do you think are the immediate reasons for some of these developments we have? Do you think, without preempting you, what do you think are the reasons for this development where we have a miscalculation or misalignment between issue of prior detention and sentencing when the court eventually, you know, gives its sentence?
So I would say it's on both sides, which the court and the defense counsel. A lot of times, because for the court ordinarily should take cognizance of the provision of the law that relates to sentencing. So bringing into perspective Section 315 of the ACJL, that's shortened for Administration of Criminal Justice Law of Lagos State 2015. So it would then mean that a court that would not consider this provision, which is mandatory, must have inadvertently, you know, overlooked that provision.
Absolutely.
By that reason, the court would not factor in prior detention. And on the side of the defense counsel, as counsel providing legal representation to an accused person, you are supposed to represent the accused person to the best of your ability.
Absolutely.
And that would mean leading evidence to show prior detention before conviction. So what it means then that the court doesn't take into consideration would be that the defense counsel perhaps also failed to draw the court's attention to this important provision of the law, which is why we would have situations like this.
I quite agree with you, really. And maybe this was will take us to the next question, which I've sort of preempted earlier when I mentioned the case of Akande and the state. And this is where I want to ask you, in your exposure, in your experience, do you know one or two cases that this development has occurred, and what has been the position of the appellate court perhaps on review of those cases? So
an instance is Nwokedi and the state of Lagos. It's a 2021 decision. And in that case, the lower court did not apply this provision in imposing a sentence. In that case, it was a conviction on the offense of manslaughter. The court ordinarily could impose a life imprisonment but in exercise of that discretionary, power, the court reduced the sentence to 15 years without considering prior detention of the accused person. The case went on appeal, and the Court of Appeal, in reducing the sentence, held that the court ought to have factored in prior detention because the accused person was actually in prison from 2014 to 2016. That's a period of about 3 years, thereabouts. So the court reduced it from 15 years to 12 years, 6 months. So it shows the importance of the mandatoriness of that provision, even though the exercise of the power of sentencing is discretionary. But the provision of Section 315 then mandates it. It makes it mandatory that the court should consider it. So what it does is to allow the appellate court to review that decision for the purpose of taking the period into consideration. So these are some of the cases. There's also Monsuru against Federal Republic of Nigeria. These are clear cases where the court has reversed a sentence or reduced the sentence on the basis of non-application of Section 315 of the ACJL.
Like I mentioned, this is actually a good, news. I would say that there are actually decided cases in this regard. So this would probably bring me to my penultimate question, or probably last question here, which is where this has happened, where a miscalculation has occurred, an error in this regard. What do you think is, what are the options open to the defendant or the defendant counsel in the circumstance?
The options open, and like we've discussed regarding appellate court's decisions, will be to appeal against that sentence. Mind you, it is not an appeal against the judgment convicting. It's separate, because sentencing is distinct from judgment convicting an accused person. So it's an appeal against the sentencing of that accused person, essentially asking the appellate court to review that decision. And usually it would be assumed that the courts, an application could be made to the same court to review the decision. But if you look at the nature of that situation, it is a sentence made per inquirium, which means it was made by the court with that in inadvertence of that a statutory provision. So then it would mean that an appellate court has to review that decision. The same court that made that judgment, that made a conviction, cannot review that decision because it is now functus officio. It lacks the capacity to do so. So it would then mean that that appeal has to go to the Court of Appeal in that instance, which is why we have Wokedi, and the state of Lagos State, and Monsuru and Federal Republic of Nigeria, because the decisions had to be taken to the appellate court for review.
I like the way you've mentioned also the possibility of an application to the court, and also shown the limitation to that strategy. So it would appear really that the option that may most be viable to a defendant or defendant counsel would be an appeal. Thank you so much again for having you or joining us today at KENNA Law Café. I think you've really shown a lot of perspective to this issue discussed. Thank you so much.
Thank you, Qudus.
And to our viewers, we are really, really pleased for having you join us today. Thank you.